Muslim law. The first concept in Muslim law is who is a Muslim. So, who is a Muslim? The definition of Muslim is the person who believes in one God and he believes that Prophet Muhammad is the final messenger of the God. To be a Muslim, he has to believe that there is only one God and the Prophet Muhammad is the messenger of the God. If he believes that, then he is a Muslim. There are two types of Muslim: Muslim by birth and Muslim by conversion. So, who is Muslim by birth? A Muslim by birth is a person who has both of his parents Muslim. A person whose both parents are Muslims is Muslim by birth. And also, if a person has one parent Muslim and one parent Hindu and he is brought up as a Muslim, then he is Muslim by birth. Either both of his parents should be Muslim, or if his one parent is Muslim and other parent is of different religion and he is brought up as a Muslim, then he is Muslim by birth. The next is Muslim by conversion. So a person can convert to Islam and he will be called as a Muslim by conversion. There are two types of converts. One is who profess Islam totally. The one type of convert is he accepts Islam totally and professes the religion completely as a Muslim. The second type of is formal conversion. The formal converts, what they do is they keep certain customs. They follow their previous religion customs, but they also accept Islam and follow Islam. So there are two types of converts who profess Islam totally, and there are formal conversions. Effects of conversion. So what is the effect of conversion? Some people, what they do malicious conversions. They have a dishonest intention when they get converted. Like for example, Islam allows bigamy or polygamy. Islam allows marriage of multiple marriages. So to utilize this feature, the other religion people they convert to Islam just so that they can marry more than one. So there are case laws. A question will come on that about the dishonest intention marriage conversion. So you have to write this. It's a 10 marks question. Who is a Muslim and the effects of malicious conversion? Decide with the decided cases. So the first case is Kenyan versus Ode. In this, what happens is a Christian who is already married keeps a concubine. He keeps a concubine and cohabits a relationship with her. So in Christian polygamy is not allowed. They can only marry one. So to marry her again, marry another wife, he gets converted. They both got converted to Islam. The court held that the conversion was malicious because they did not convert to profess their religion. They got converted so that they can use the polygamy feature of Islam. The next case is MST Ration Bibi versus Khuda Baksh. In this, what happens was there was a Muslim couple, and the wife, to get rid of her husband, got converted to Hinduism. So when she got converted to Hinduism, she asked for divorce because she is now a Hindu and the marriage cannot subsist. The judge, what he does is he asks to bring a plate of pork and brings in front of the wife and asks her to eat the plate of pork, and the wife refuses to eat the plate of pork. So the judge concludes that her conversion was malicious to Hinduism. She did not convert to Hinduism so that she can profess to that Hinduism, but she got converted to Hinduism so that she can get rid of her husband. The next case is Rukia Baby versus Anil Kumar. In this, there is a Hindu couple, and the wife has an important husband. And to get rid of her husband, she gets converted to Islam. The court also held that this conversion was malicious. In the next case, Sarla Mudgal versus Union of India. This is the landmark case. In this, the court held that if the marriage is between the Hindu, or if at least one person is a Hindu, then the divorce should be taken through Hindu only. If they don't take divorce through Hindu and get married, then according to section 494 IPC, it is punishable bigamy. So if the marriage has taken place according to Hinduism, and one person gets converted to Islam, say the man get converted to Islam, and if he wants to marry another wife, he will have to compulsorily take divorce as a Hindu first. Only then he can marry another wife. Or else, if according to section 494 of IPC, he will be punishable for bigamy. The next topic is Shariat Act. It is usually asked for 6 marks. So, what is Shariat Act? See, Shariat Act has two concepts. I have divided it as A and B. The first concept tells about everything that applies for a Muslim in India. All of the laws of Muslim Islam that applies to the Muslim in India are under Shariat Act. The first A, what are the concept? What are all the laws of Quran and Hadith or whatever the laws of Islam that are applicable to Muslims in India are marriage laws, maintenance laws, dissolution of marriage laws, dower, guardianship, gifts, trust, trust and properties, works except charitable institution and religious and charitable endowments. It is given in section 2. So whatever is given in the part A is applicable to all Muslims in India. In the part B, convert may govern by custom. See, convert, apart from all that, he can be governed by custom if he is a formal conversion. So adoption, wills and legacies unless filed declaration. So adoptions, wills and legacies, the convert can choose to be governed by customs. He can choose to be governed by customs in adoption, wills and legacies of his previous religion unless he files a declaration. Examples for these are Khojas, Bohras, Kachi Halai Memes, Girasas of Burj. See, these Khojas, Bohras, and Kachi Halai Memes, they are complete villages or cities, and overnight they all get converted to Islam. But they had certain their previous customs of adoption wills and legacies, so they decided to keep their customs of adoption wills and legacies. The next is convert not covered in section 2 and section 3. See, section 2 tells about whatever the laws that are applicable to Muslims in India. If that law is not mentioned in their custom, then the custom is applicable to them. For example, if a Hindu co-partner gets converted, if a Hindu undivided family gets converted, then the Hindu has their own unique concept of joint family property, which is not in Islam. So it is obviously not covered in section 2. Then, if the Hindu undivided family, after getting converted to Islam, they can keep their custom of dividing the Hindu undivided family property through by Hindu law, and they can still be called as Muslim. The next is Section 2 excludes agricultural lands, charities, and charitable religious institution. So, agricultural lands, charities, and charitable and religious institution are not governed by Islamic law to Muslims. Application of customs by statutes in British. British made certain statutes that are also applicable to converts. There is a case Nurjahan versus E. Tyson Co. So in this case, it was decided that marriage and divorce only if both parties Muslim. So if one party is Muslim and another party is Hindu, they both cannot get a divorce through Muslim law. They have to compulsory get a divorce through Hindu law. If one party is Muslim, another party is Christian, then they can't get a divorce through Muslim law. They will have to get divorce through Christian law. Similar to marriage, if one party is Hindu, another party is Muslim, they have to get married through Hindu law and not through Muslim law. The origin and development of Islamic law in India, not in India, the origin and development of Islamic law of Islam. It's also a 10 marks question. Origin. The origin was in Arabia, and the Quran and Hadith I will tell in sources. Development. There are totally 5 periods. The first period is in Al Hijri 1 to 10. The Al Hijri is the Islamic time period. Al Hijri starts when the Prophet Sallallahu Alaihi Wasallam, Prophet Muhammad, got his prophethood. Prophet Muhammad got his prophethood at the age of 40. So, what is a prophet? Prophet is the messenger of God. So, God sends a messenger to send his message, and that person is called prophet. So, Muhammad got his prophethood in the age of 40. So, when he took the prophethood, it marks the start of Islamic calendar, and the Islamic calendar is called Al Hijri. Like similarly, the BC, before Christ or after Christ, the birth of Jesus is the start of Western calendar. That's how there is a separate Islamic calendar, and the prophethood, the acceptance of prophethood of Muhammad starts the Islamic calendar, and it is called Al Hijri. So there are totally 5 periods in which Islam is developed. Al Hijri 1 to 10, the first period. Al Hijri 10 to 40, the second period. Al Hijri 40 to 300, the third period. Al-Hijri 300 to 1924 AD, the fourth period, and the modern period, the fifth period, 1914 AD to present. So Al-Hijri 1 to 10, the first period. In the first period, Al-Hijri 1 to 10, you have to talk about the lifestyle of Prophet Muhammad. In the first period, you have to talk about the lifestyle of Prophet Muhammad. The Prophet Muhammad was born in 570 AD, and he used to go to cave Hira for worship. And when he was going to cave Hira for worship, one day he got the Wahi, and he got his prophethood also. Khatija, Warqa, and Abu Bakr were the first persons who accepted Islam under his hand. When he got his prophethood, he was still in Mecca, but the Meccan people did not welcome his message of Islam, so they threatened him for life. And because of that, he had to flee to Medina. And he went to when he fled to Medina, the Quran and the Quran wahis, the Quran ayats or the Quran inspirations increased. During his period of Mecca, the revelations, all the revelations of Quran he got aware of a lifestyle and how to profess religion and all. But when he fled to Medina, all the inspirations that he got was the rules of law. So it was this time the he got inspiration of Quran and also the development of ahadith. The second in the this is the conclusion of first period. You have to talk about the Prophet Muhammad, how he got Quran and all, and he fled to Medina. And Khatija and Abu Bakr were the first person to accept Islam, and he got his prophethood. That how you have to tell in first period. Second period, Al Hijri 10 to Al Hijri 40. The second in the second period, the Al Hijri 10, it is the demise of the Prophet. The Prophet Muhammad died in the second period, and you have to talk about the four caliphs of Prophet Muhammad, four disciples. See, Prophet Muhammad has four prominent disciples: Abu Bakr, Umar, Usman, and Ali. You have to remember these names: Abu Bakr, Umar, Usman, and Ali. These are the four main disciples of Prophet Muhammad. And in second period, you have to write about them itself. See, after the demise of the Prophet, these four disciples took the leadership. The first caliph or the first ruler was Abu Bakr, and after his demise, the second ruler was Umar, and after Umar's demise, the third ruler was Usman, and after Usman's demise, the fourth ruler was Ali. So the third ruler Usman, what he did was he collected all the Quran copies and made and developed a original copy. See, what happened was Prophet Muhammad was an illiterate. So whenever he got inspiration, he used to ask his disciple to write it down. So Abu Bakr, Umar, Usman, and Ali, and all of his disciples used to write it down in a paper or whatever they got, not in paper, whatever swords or stones, whatever they had in hand, they used to write it there. And after they have written, the Prophet Muhammad used to ask Abu Bakr only to get up and read it. And when he read it, the Prophet Muhammad only verified the copy of Abu Bakr. He used to ask Abu Bakr to read it. So what Usman did was he burnt all the other copies and only the Abu Bakr's written copy he preserved and collected everything and gathered and make a solid copy of Quran in the second period. You have to write this. And even in the second period, the Muslims got divided into Umayyads and Hashemites. You have to also mention this also. In second period, you have to mention about the four caliphs, Abu Bakr, Umar, Usman, and Ali. And you have to mention that Usman collected the Quran and made a single copy. And you have to also mention that the Muslims in second period got divided into Umayyads and Hashemites. The third period, Al-Hijri 40 to Al-Hijri 300, you have to write about schools of Islam. So what are the schools of Islamic law? I will tell in the school section, but I will tell names itself, only names here. You have to mention Sunni schools and Shia schools, Hanafi school, Maliki school, Shafi school, Hanbali school. In school section, I will tell it in detail. So in Al-Hijri 40 to Al-Hijri 300, you have to mention all about schools. The fourth period, Al-Hijri 300 to Al-Hijri 924 AD. In this period, you have to mention about Ijtihad and Taqlid. The two major concepts in Al-Hijri, the fourth period, you have to mention about Ijtihad and Taqlid. See, in this period, they after the demise of all the caliphs also, they started appointing an imam. So who is an imam? According to Sunni, imam is a supreme leader, but according to Shia, imam is a supreme lawgiver. So they started appointing an imam. So there was an efforts of jurists to develop Islamic law. So it gave rise to ijtihad and taqlid. So what is ijtihad? Ijtihad is exerting oneself to utmost degree to attain an object. So what this ijtihad and taqlid are, see the Quran and Sunnah, they don't speak about everything. There are when modern problems started to arise, it was a need to study law and increase the Quranic laws. So what they made was they started doing these ijtihad and taqlid type things, and they started adding laws to the Islam. So what is ijtihad is exerting oneself to the utmost degree to attain an object. So the person here is mujtahid. Here's the person called mujtahid, and he does the ijtihad. He reads the Quran and learns the Quran. He reads the Sunnah and learns the Sunnah. And he according to his analogical deduction, he tells something. He finds a solution. The next is taqlid. Taqlid is imitation, and the leaders in the taqlid are muftis. The leaders in the ijtihad is mujtahid, and the leaders in the taqlid is mufti. So what is imitation? See, the learned scholars of the Muslims, what they people used to do was they used to follow the scholars itself. That is called taqlid, imitation. Taqlid means imitation. If a person gets learns Islam perfectly, then the people used to start following him, and what he does is the law for them. That is taqlid. The fifth period, 1940-24 AD to present. In this, you have to write about the establishment of British rule, then the IPC 1860. So the criminal law of Islam does not apply to Muslims in India. IPC, we have separate IPC, Indian Penal Code, that applies to Muslim in India. Not only Muslims, everyone has to follow IPC, criminal law. And there was Shariat Act, which we read, and equity, justice, and good conscience. You have to write this. These are the 5 periods. In the first period, Al Hijri to 1 to 10, you have to talk about the life of Prophet Muhammad. In Al Hijri 10 to 40, you have to talk about his 4 caliphs, Abu Bakr, Umar, Usman, and Ali. In Al Hijri 40 to 300, you have to talk about schools, write about schools. In Al Hijri 300 to 24 AD, you have to write about Ijtihad and Taqlid. In the fifth period, you have to talk about the Shariat Act, IPC, etc. It's a 10-mark question. The next is sources of Islamic law. So what are the sources of Islamic law? There are two major heads of sources. One is traditional source and other is a secondary source or modern source. The traditional sources are the primary sources and the modern sources are the secondary sources. So what are the traditional sources of Islam? The traditional or primary sources of Islam are Quran, Sunnah, Ijma, and Qiyas. And the secondary sources are customs, judicial decisions, legislation, justice, equity, and good conscience. So the Quran. First, we have to see about Quran. So what is Quran? See, Quran is the word of God. The God, Allah, through Angel Jibril, sent inspiration to Prophet Muhammad. And as I said earlier, Prophet Muhammad was an illiterate, so he used to narrate the inspiration he got to his disciples, and everyone used to write it down. And he used to verify only the copy of Abu Bakr. So Quran has almost 6,000 verses, and only 200 of those verses talks about rule of law. Only 200 verses talks about rule of law. That I have to mention in the Quran section, that it is the revelation from God, and Prophet Muhammad got it through Jibril, and he wrote it down. You also have to mention about the Usman, what he did. He collected the copy of Abu Bakr and burnt all other copies of Quran, and he collected and made a solid one copy of Quran. You have to mention Quran section. The next is Sunnah. What is Sunnah? Sunnah is the lifestyle of Prophet. The lifestyle of Prophet Muhammad it's called Sunnah. It is the way of life. It's the way of life of Prophet Muhammad. It is one of the primary sources of Islamic law. So whatever Prophet Muhammad used to do, it also becomes the law. Apart from the Quran, whatever the Prophet Muhammad used to do, like growing beard is a part of Sunnah, but it is not mentioned in Quran. And also Quran only speaks about law. For example, Quran only says that you have to read namaz or to profess namaz, but Quran does not say how to read namaz. It is the Sunnah, it is the Prophet Muhammad who teaches us how to pray namaz. That is what the difference between Quran and Sunnah is. Sunnah is the way of life of Prophet Muhammad. It is different from the Hadith. In Sunnah section, you have to mention that. And there are three types of Sunnahs. Sunnatul Qawl, that is the words directly spoken by the Prophet Muhammad. The words that are directly spoken by the Prophet Muhammad is called Sunnatul Qawl, and there is Sunnatul Fal. It is the conduct of Prophet Muhammad. Prophet Muhammad did not say anything, but he used to do his way of life. It's called Sunnatul Fal. And there are actually other two types of sunnahs also, like the ancient period sunnah and the of ancient period sunnah. What happened was before, if Quran does not mention some law, then what Prophet Muhammad used to do was he used to take the laws from the pre-Islamic period, the customs, and he used to follow it. The sunnahs of the previous prophets, he used to follow it, and then he has his own sunnah. The next is ijma. The next primary source is ijma. So we saw about Quran. Quran is the revelation of God, which Prophet Muhammad got to the angel Jibril and used to narrate it to his disciples. And and he used to verify only Abu Bakr's copy. And Usman gathered Abu Bakr's copy and burnt all other copies. And that we have the primary source of law is Quran. The next we saw Sunnah. Sunnah is the way of life of Prophet. And we have two types of sunnahs, Sunnatul Qawl, which is word spoken, and Sunnatul Fal, which is the conduct of the Prophet. The third source, we have Ijma. See, Ijma means consensus. So what is consensus? See, Quran and Sunnah does not speak about all of the aspects. In modern times, we will have modern problems, of course. And Quran and Sunnah it is not possible to cover everything. So it gives rise to ijma. Ijma was mainly developed during the schools, the prominent imams, the imams of the schools, Imam Malik, Imam Shafi, Imam Hanbal. It was that time the ijma was developed. So ijma means a consensus. Only Imam Hanbal rejected the concept of ijma. The rest, all of the imams, Imam Malik, Imam Hanaf, and Imam Shafi, accepted ijma. That you have to write. Ijma means consensus. So you have to also write this also, that Quran and Sunnah does not cover all of the aspects that gives rise to ijma. So these three are the ancient sources of Islamic law. The qiyas, what qiyas is? Qiyas means analogical deduction. So what in qiyas, what it does is we take laws from Quran, Sunnah, and ijma, and with the logical reasoning of the person, law is deduced. So it is not accepted by everyone. Even in Shias, it is not accepted. But it's the source, one of the source, qiyas. The secondary sources are customs. See, customs mainly apply to the converts. Like we saw in the Shariat Act, you have to mention that the Khojas, Bohras, they are still governed by the customs. The converts, they can keep customs and also profess a religion. That you have to mention. There are certain rules for customs. When is a custom valid? The custom is valid that it should be of a regular occurrence. Custom is valid if it has a regular occurrence, and it should be universal, it should be reasonable, and it should not be in contravention of any express text of the Quran or the Sunnah. The custom, if it is not opposed to the Quran and Sunnah, and if it has a regular occurrence and it is universal, then the custom is accepted. But in India, custom is only applied to converts. We saw in Shariat Act. Shariat Act have to mention in customs. The next is judicial decisions. Judicial decisions also called as precedents. You have to mention here Shara Bano versus Union of India case, the case in which the triple talaq was totally abolished, the landmark case. You have to mention in judicial decisions. The Shara Bano versus Union of India case, what happened was the triple talaq was totally abolished. So precedents also holds a value in deducing the source of Islamic law. There are modern sources. Legislation. In legislation, you have to mention acts, the Shariat Act, the Muslim Women Protection Act, the Waqf Act. You have to mention that the legislation, the coded laws. The next is justice, equity, and good conscience. In justice, equity, and good conscience, if all the other sources fail, then the person can decide through justice, equity, and good conscience. That's what it says. These are the sources of Islamic law. We have primary sources and secondary sources. The next is schools of Islamic law. So the schools of Islamic law are divided into two types, the Sunni school and Shia school. Sunni school has Hanafi school, Maliki school, Shafi school, and Hanbali school. And the Shia school has the Zaydi school, the Ismaili school, and the Ithna Asharis. In India, the Sunnis follow the Hanafi school, and in India, the Shias follow the Ithna Asharia school. Only two schools are there in India, the Hanafi school and Ithna Asharis. So we'll see one by one. The Hanafi school. See, the Hanafi school, It was developed by the Imam Hanifa, Imam Abu Hanifa. He was the founder of the Hanafi school. What he did was he mainly focused upon Islamic jurisprudence. We have subject jurisprudence now in third sem. So Islamic jurisprudence, he used to develop it. He used to talk about Islamic jurisprudence. The Imam Abu Hanifa is also called as the founder of Islamic jurisprudence. He mainly focused upon the qiyas, the one of the Islamic source of primary source. He mainly focused on qiyas. And there were in his time there were two groups, Hijaz and Iraq. The Hijaz group mainly focused upon traditions. Traditions means the Sunnah of Prophet are called traditions. And the second group, Iraq, concentrated on private opinions. Hanafi believed in private opinions. He believed in istihsan, equity. So what is this istihsan? It is the form in which the ijma is deduced. So I said in the sources that ijma was developed mostly by the four imams, the Imam Abu Hanifa, Imam Malik, Imam Shafi, the three imams. So they had their own way of deducing ijma. So how they deduced was Imam Abu Hanifa, he deduced ijma through istihsan. What is istihsan? Istihsan means equity. He come to the decision of ijma through equity. He believed in equity, istihsan, and he believed that ijma is valid in every age. Ijma is the primary source in every age. He believed, but he did not also neglect traditions. So the Hanafi school is followed in Iraq, India, and Soviet and China. There are four countries where Hanafi school is followed: Iraq, India, Soviet Union, and China. The next is the Maliki school. Malik school came into existence in Al-Hijri 95. So he was also one of the jurists. He believes in traditions, that is Sunnah. Also believed in Quran and Sunnah. He also believed in Ijma. And his unique concept was Muslahat. What is Muslahat means? Public opinion. It is also called as Istadlal, principle of logical deduction. So the Imam Malik, how he came to deduce his how he came to deduce his Ijma was through Istadlal, through public opinions. He used to take public opinions and he used to deduce the source of Ijma. Imam Malik. And he wrote certain books. It is called Kitabul Mawatta. One book he wrote, Kitabul Muwatta. And Maliki school is mostly spread in West. So see, in schools, what you have to write is what they used to believe, which source they used to believe. Say like for example, the Hanafi school, he believed in Islamic jurisprudence. He believed in Quran. He believed in Qiyas, the primary source, and he also believed in Istihsan. And which countries they are spread. You have to write 4 points at least, which the primary source they used to believe, and which countries it is spread, and what was the way through which they deduce the ijma. So Hanafi, Imam Hanifa, he deduced the ijma through istihsan, equity. That you have to write. The next is Maliki school. You have to mention which sources he used to follow. Like for example, he used to follow traditional traditions, Quran, Sunnah, and ijma he used to follow, and how he deduced the ijma was through public order, through muslahat. You have to mention, and you have to mention which country it is spread. It is spread west spread. The next is Shafi school. Imam Shafi. Imam Shafi was the disciple of Imam Malik. Imam Shafi was the disciple of Imam Malik. So he was a traditionalist. Traditionalist means the people who follow Sunnah are called traditionalist. The people who follow only the lifestyle of Prophet are called traditionalist. And but he also followed logical reasoning. He believed in classical theory of Muslim jurisprudence. So Imam Shafi is the founder of classical theory of Muslim jurisprudence. He believed in the science of usul. He perfected the ijma. Imam Shafi, it is during his time the ijma was perfected, and his approach to ijma was istadlal. Through istadlal, he approached the way of ijma. So Imam Abu Hanifa, we saw he approached ijma through equity, istihsan. Then we saw Imam Malik. He approached ijma through public order, and Imam Shafi, he approached ijma through istadlal. He rejected jurist equity. He also rejected taqlid. So his books are Kitabul and Usul al-Fiqh. The countries where Imam Shafi's school is followed is Indonesia, Malaysia, Southeast Asia. The next is Hanbali school. The Imam was a disciple of Imam Shafi. He was a solid traditionalist. He did not believe in anything else but Quran and Sunnah. He did not even believe in Ijma. He did not even believe in Qiyas. The only sources he followed was the Quran and Sunnah. He was a solid traditionalist. The people who follow Imam Hanbal are Wahhabis. The countries which follow Imam Hanbal is Saudi Arabia and Qatar. Shia schools. Their Shia schools are Itna Ashariya schools. The Itna Ashariyas are also called as Twelvers. The founder of Itna Ashariya was Jafar Siddiq. And it is during the Itna Ashars that Muta Marriage came into existence. They were the founder of Muta Marriage. They believed in Muta Marriage. Ismailis. The Ismailis are called as Seveners. Imad al Maktoum is the founder of Ismailis. In India, Khojas and Bohras follow this school, the Ismailis. Other than that, everyone follow Itna Ashar schools. The third is Zaid school. The founder is Imam Zaid, and the Zaidi school is close to the Hanbali school. That's are the schools of Islamic law. Muslim marriage. So, what is a Muslim marriage? The Wilson defines Muslim marriage as it is the legalization of sexual intercourse and also the legalization of procreation of children. It's called Muslim marriage. Muslim marriage is legalization of sexual intercourse and also legalization of procreation of children. It's called Muslim marriage. Also, Justice Mahmoud J defines Muslim marriage as a civil contract. So Muslim marriage is purely like a contract. Unlike Hindu law, Hindu law believes that marriage is a sacrament, but Islam does not believe that marriage is a sacrament. Islam believes that marriage is a contract. There are two kinds of marriage. One is nikah, the normal marriage. The other kind of marriage is muta marriage. See, in muta marriage, the term of marriage is fixed. Like for example, the nikah or the normal marriage is permanent. Once you get married, it's for lifetime until you take divorce. But in muta marriage, that's not the case. In muta marriage, a term is fixed. Like for example, 1 year, 2 year, 3 year, a term is fixed, and after that term finishes, the automatically divorce happens. So muta marriage. What is muta marriage? As I said, muta marriage is a temporary marriage, but there is a doer. Doer is specified in muta marriage. So what is a doer? Doer is the pure concept of Islam. Whenever couple gets married, the husband has to give something, a consideration for marriage to the bride, and that is called doer. For marriage, the groom has to give consideration for bride, money, gold, or anything, what or property, whatever he gives, it is called doer. So in Muta marriage, doer is also specified, but the term of marriage is fixed. The marriage is not permanent, and only Shias believe in Muta marriage. Sunnis do not believe in Muta marriage. Only Shias believe in Muta marriage. And in Sunni, it is also haram. Muta marriage is haram. Only Shias believe in Muta marriage. So this is one case: Shohrat Singh versus MST Jafri Bibi. In this case, it was decided that if the term is not stipulated during the muta marriage, if the bride and groom does not decide the term of the marriage, then according to law, it will be considered as a permanent marriage. It will not be considered as a muta marriage. So, what are the incidents of muta marriage? What will happen when a couple goes into a muta marriage? So, no mutual inheritance. The bride and groom cannot mutually inherit their property. No mutual inheritance. No wife maintenance. The wife is not entitled to maintenance in muta marriage. But according to section 125 CRPC, the judge can give her a maintenance claim. The next incident is if marriage is consummated, only then she will receive full dower. If marriage is not consummated, she will receive only half dower. The next is if the marriage is consummated, then the wife will have to observe iddat period. So what is iddat period? See, whenever the husband and wife gets divorced, the wife has to observe a period of iddat of 3 months. During the period of iddat, she cannot get remarried. Only after the completion of iddat period, she can get married. That is called iddat period. So if the marriage is consummated, the wife will have to observe the iddat period of 3 months. Until that 3 months, she cannot get married. Husband can refuse to children. In muta marriage, the husband has the right to refuse the birth of children. He can refuse. He has that right. But if in case children are born, then the marriage will be considered as legal. The muta marriage ends when term ends without divorce. The muta marriage ends as soon as the term ends, and the divorce is not necessary for muta marriage. Classification of marriage. There are three kinds of marriage: Sahi marriage, Batil marriage, Fasid marriage. Sahi marriage is the valid marriage, Batil marriage is the void marriage, and Fasid marriage is the irregular marriage. Only Sunnis believe in all three types of marriages. Shias only believe in Sahi marriage and Batil marriage. For Shias, even fasid marriage is void marriage. Even irregular marriage is void marriage. So what are the steps of marriages? We will